accused the present may so long be seated. Yes.
We're not fed. We haven't eaten since morning.
Thank you for telling me.
Also, I got an indication from accused 2 that he needs to approach us. We're not allowed to go downstairs and take instructions or have any discussions. Is it possible for my attorney just to approach accused number 2 and hear what the issue is?
Accused 1. Thank you.
Well, he's not here.
My attorney as well. Thank you. My lord.
We're missing accused 1. Mashiani, where's the court orderly? Because there seems to be a problem getting number 1. Yeah, there he is.
I haven't seen the court orderly since we came back from lunch adjournment. I assume he's still underground now.
Can you get him back?
I haven't had any updates as to why.
Well, we need to get him back.
Yes, ma'am.
Right. Yes.
May it please the court. My lord, unfortunately, we haven't had any luck also during the lunch hour. We have endeavored, but I'll leave that over. I'm going to continue at this point. My lord, when it comes to the events that occurred during the 4 days from the kidnapping through to the time when Krejcir was released, I respectfully submit to your lordship that your lordship failed to take into account that the only person that identified accused number 2 as being involved in this process is Peter and Paul. They the 2 people. And your lordship in your judgment deals with this, with a process under the heading of the hunters. When your lordship then analyzes the evidence of Peter and Paul, we respectfully submit your lordship failed to take into account what we believe is the most important aspect pertaining to their evidence, apart from the fact, of course, that there are accomplices, and to an extent, certain of the events, Peter is vis-a-vis accused number 2 a single witness, is the fact that their cellular data was subpoenaed and it was dealt with during the course of the trial. And we submit that it constitutes objective evidence, and insofar as it is objective evidence, it contradicts the viva voce evidence of both Peter and Paul in material respects. And because of the fact, my lord, that it is so important that your lordship should have analysed it and taken into account also vis-a-vis accused number 2's version, which we submit is corroborated through their cellular data, we've actually gone again and dealt with it with each of the dates, where we say they contradict their viva voce evidence, where it contradicts their evidence with regard or vis-a-vis each other, and where we submit it's there's a failure on the state's part to prove the events as they alleged right from the start. Now, Your Lordship, in particular, we submit did not properly deal with the issue of Peter's cellular data that shows him to have gone to Ermelo on a totally separate day as the evidence that was presented by the rest of the witnesses.
Why would you have gone to Ermelo at all?
My Lord, I'm going to come to the issue of the going to Ermelo, and when I deal with certain...
No, you say it's a wrong day, but surely the question is, did he go there? And why did he go there? That's the question.
But there's a further question, my Lord. Let's stop there. There's a further question. The question as to on whose instructions does he go there? And why does he go there?
That's a different issue versus the day.
But the point is, and why we say it's important and significant, my Lord, is because Your Lordship would recall the evidence was that during this whole trip to Ermelo, present were inter alia accused number 2, there was meetings at Money Point, what time the alleged meeting started at Money Point, all of that forms part of the evidence. Present was Paul. Paul, in fact, went there. None of that is borne out by the cellular data, because we've got, on the version of Peter, there was a meeting. The meeting happened at about 6 o'clock, and from there on they stayed at Money Point. There was various things that happened, and yet, my Lord, if we analyze the cellular data, we see that on his own cellular data, he phoned accused number 2 on a number of occasions. He phones Peter, so his evidence as to what transpired prior and during the trip to Ermelo is not borne out at all by the cellular data. It also contradicts the times in which they allegedly went to Ermelo and what transpired the following day. So we submit that if Your Lordship paid attention and analysed as we've done,
I don't think that's a proper submission.
I submit, my Lord,
To say that I didn't pay attention.
Well, if Your Lordship analysed the evidence,
I think that's not the test, and it's impertinent.
as the court pleases, my Lord, we submit that Your Lordship erred not taking into account the evidence, the objective evidence, as to what transpired on the Ermelo day, as well as the day after that.
Yes.
My Lord, we also then deal with the issue of the events that on the version of Peter and Paul unfolded on Friday, and we submit that on that day, when there was allegedly a phone call from accused number 2 to come and assist, and at which time the Lukele was picked up from the safe house and then dropped off at the stadium. Again, very important aspect, it's not borne out by the evidence or by the cellular data of both Peter and Paul.
Well, he
And
was picked up, and he was taken, and he was dropped off, and he did go to the doctor the next day.
But if it is so, my Lord, with the greatest of respect, why does the cellular data not confirm it? And we know that the cellular phones were working. We see it. We see the process of it being used that day. This is not a question of it being used, let's say, in the morning and then it's off. It's used continuously through that day. And the evidence presented, the Viva Voce evidence, is absolutely not corroborated by the cellular data.
Well, I'm not sure I do. Anyway, we have different ideas on that.
My Lord,
Which page are you on now?
my Lord, I've summarized it all for Your Lordship from where I started, if Your Lordship would just bear with me. From approximately, page 12 through to page 28. All
Okay.
the objective evidence vis-a-vis the cellular data, vis-a-vis the 2 Peter and Paul's evidence, and then that as opposed to the version of accused number 2.
Yeah, thank you.
My Lord, we then submit to Your Lordship that, again, when we deal with the issue of fair trial, and we find it on page 28, we submit...
Just wait, I'm going there. 28, yeah.
We submit with respect, my Lord, that there's a number of issues that's quite important pertaining to the issue of a fair trial. And we submit that these issues not only pertains to the trial itself, but also to the pre-trial. And in that regard, my Lord, we submit that these can basically be summarized as follows. The issue of the identification parade, we say that there should have been an identification parade. We then, in paragraph 56, my Lord, we submit that there's an onus on the state, and again, by the state we mean the extended arm of the state, the police and the prosecutor, to properly investigate an aversion put forward by an accused. Now, the version of...
Even if the version is unsubstantiated in fact.
My Lord, how does one...
Well, you can't answer it by giving me a rhetorical question. You've got to answer the question. If it's unsubstantiated in fact, why do they have to do anything?
My Lord, we respectfully submit it's not unsubstantiated in fact.
Yeah.
We went and we proved the presence of Pumi Piri and the other person vis-a-vis AVL, in other words, movement vehicle reports. We've established the contact between Colonel Kimba and Peter and Paul. We've placed all these facts on record, not only through Viva Voce evidence, my Lord, but through objective evidence. And yet, despite that, and despite what we submit is the onus on the state, neither my learned friend nor the police, in any form or manner, endeavours to investigate the version put forward by the accused. And we submit that in our law there is an onus, and your Lordship should have taken it into account when your Lordship evaluated the evidence, and in not doing so, your Lordship erred. My Lord, in the same vein, we submit that your Lordship's refusal to allow accused number 2 access to the cellular data of Colonel Kimba constitutes an irregularity that infringes his right to a fair trial. Now, your Lordship would recall that he was duly subpoenaed, so to the cellular data network, and instead of, we submit, dealing with the issue as to whether there's an objection or not in him providing his cellular data to the defense to exercise their constitutional rights as to either adduce or challenge certain evidence, your Lordship requested the defense whether they're going to call him, and when we said we couldn't call him, and explained to your Lordship why we can't at this stage call him as a witness, your Lordship excused him. We submit that that is a fatal irregularity. We were not allowed to exercise our rights in terms of the Constitution. We couldn't get access to the data. And the only means through which we could have gotten, it didn't succeed because of what we submit is an irregularity that was committed during the course of the trial. My Lord, we furthermore submit that your Lordship erred in not calling either Colonel Kimba or Pumi Piri or the other witness. And we submit that your Lordship's failure to adhere to the request by the defense at that stage in the interest of justice to call those witnesses constitute an irregularity. Lord, we further submit that, and this is directly linked to the submission just before this, that there was evidence, we submit that the evidence in this court clearly proved that Captain Ramohala blatantly lied to the court about his knowledge of Colonel Kimba. Which your Lordship would recall that the point at which he indicated to this honourable court that he's not answering further questions because he's going to incriminate himself was at the very point where he was confronted with the issue of Colonel Kimba and his knowledge of Colonel Kimba and whether he knows him or not, and of Colonel Kimba's involvement in this particular matter. Now, we submit, my Lord, that it If it is so, as the version is of accused number 2, that Colonel Kimba was involved in the attempt to find the money, and even on your lordship,
To do what?
on accused number 2's version is that there was a search for money. The state version is there was a search for a bag. Whichever version if Colonel Kimba our submission, my lord, because he's in a perfect position because of his intimate knowledge of what transpired in that period and of his involvement to manipulate evidence.
But there's no evidence that he did manipulate evidence, or that evidence was manipulated.
My lord,
It's a theory that you've had.
But it's a submission, my lord.
You think he's
that
going to
even-
come if I call him as a witness and say I've manipulated the evidence?
No,
He's
my
not
lord.
going to. So then what's the point of calling him?
The point would have been, my lord, to establish exactly what his role was in this matter.
Well, he's going to say he had nothing to do with it. Let's assume. So what? If
but
he said he
you're-
did have something to do with it, how did it change the evidence against the accused?
But my lord,
It has
we,
nothing to do with this
we
case.
submit by calling him, it could have materially changed the evidence.
Changed what?
As to the confirmation of accused two's version, your lordship could potentially have found that he's lying
So what
about
if he's
his
lying?
whole role in this.
So
Your
what
lord-
if he's lying?
but,
Let's assume he's lying.
but our submission is your lordship has
You want me
made-
to call a liar to come and say something? What
what
for?
we're saying, your lordship has not afforded us an opportunity
Yeah.
to deal with his
Yes,
evidence.
well, I've heard the submission. Same submission.
My lord, I then need to deal with the two other aspects, and I'm going to,
Which are?
and that pertains to the special entry. There's a possibility that, depending on what happens, that it will form either the part of a special entry, or I will then deal with it in further submissions. But I can't at this stage take that issue further. So I'm going to ask your lordship's indulgence then to deal with this
Well,
aspect.
the distinction between the special entry and whether it's part of the appeal is whether or not it's on the record.
Indeed, my
Well,
lord.
everything's on the record because nothing happened off the record.
I'm going to leave my submission there at this point. I know exactly what the difference is, my lord, but there is, in my respectful submission, having had regard to what the instructions are, I could potentially deal with it depending on what happens in a different manner. And I'm asking your lordship's indulgence in that regard. As
So you want to wait until after the state's argued?
I've got no issue
Or you
with-
want to argue that now?
No, I can deal with it then after the state's argument.
Are you happy to argue partially and then perhaps have to deal with a special entry later, Mr. Mashiane?
My lord, I submit it will only be proper if I had to respond to all the submissions.
Well, why
made.
can't you carry on at least insofar as the other accused are concerned and argue?
But now, my lord,
So the special entry is a freestanding issue.
yes, I understand that, my lord. However, the submission by my learned friend
Well,
is,
I'll give you a chance to argue. I think you must carry on.
so I'll be given a chance to argue
Yes,
further
well-
after,
Obviously, everyone will get it. Yes, because
Yes,
they're
yes.
going to deal with it.
as the court
Yes.
proceeds.
So I understand. Let me just stop. I understand you're finished now. For
I'm
temporarily.
finished at this
Pro
point,
tem.
except for that.
Right, Mr. Mashiane. Let's hear you on whatever's been argued up to date.
Thank you. My lord,
On the basis that the special entry issues, I will give you all a chance to deal with separately.
yes. It's my submission, my lord, that most of the issues brought forward in today's proceedings, my lord, are the issues that had already been dealt with in the arguments in the main trial. There's only some few aspects that I need to respond to, my lord. I submit, my lord, for the counsel for accused number 1 had indicated, my lord, that the that leave to appeal should be granted because the court erred in evaluating the standard of proof. I submit, my lord, that it's not the case that the court only look at the probabilities. My submission, my lord, is we need to look at the probabilities in order for one to come to a conclusion whether the case has been proven beyond reasonable doubt or not. And that is exactly what this court did. We don't look at the probabilities and leave it there. The probabilities lead one to a conclusion whether the state had proven its case beyond reasonable doubt or not. And I submit, my lord, the court did not misdirect itself when looking at the probabilities ultimately as to the question whether the accused guilt has been proven beyond reasonable doubt or not. Now, my lord, the further criticism has been leveled that the court relied on the evidence of Lukele, but does not accept all of his evidence. I submit, my lord, my learned friend is failing, my lord, in indicating to this court that in addition to the evidence of Lukele as regards the identification, we also have the evidence of Peter and Paul. And we not looking at the evidence of Lukele in isolation. We look at all the evidence that has been led before this court and therefore come to a conclusion whether the identification has been proven beyond reasonable doubt or not. And I submit, when we look at the evidence of both Lukele, Peter, and Paul, one can only come to one conclusion, my lord, that such identification has been proven beyond reasonable doubt. Therefore, I submit the court did not misdirect itself in that regard. Now, the other issue, my lord, that my learned friends, in fact, my learned friends for accused 1 and 3 to 6, my lord, they made submissions on the issue of the dog identification. I submit, my lord, and and this issue, my lord, was also dealt with at length in my heads of arguments during the trial to say there's nothing wrong with dog identification. Because, my lord, the case law is very clear that in most cases, the accused, the victim gets the opportunity to identify the accused or the assailant during the commission of the crime and again when he is confronted in court. But now, my lord, it was not only a question of the witnesses having to say, because these are the people in court, then they are the ones who committed X, Y, Z. Again, my lord, we also have to look at the evidence in total to say, Lukele says, accused 1 poured boiling water over my face, and accused number 4 was one of the people that kidnapped me. But now, with that, my lord, we also need to bring into the picture the evidence of other witnesses. What does Peter say in regard to this, to that identification? What does Paul say in regard to that identification? And we know, my lord, that both Peter and Paul had been in the company of the accused for a number of days. They can't be making any mistake about that. In fact, my lord, accused number 2 concedes, yes, I had enrolled the assistants of Paul, who in turn enrolled the assistants of Peter. So it's common cause that Peter, Paul were there during the commission of these crimes. The only issue that one needs to ask, or one needs to tackle now is Peter and Paul, are they lying before this court about the events in question? That is the only issue before this court. But they can't be lying before this court because we now have independent corroborative evidence of Lukele about how the events evolved. We have independent corroborative evidence of the medical doctors. In particular, my lord, we now have to look at the evidence of Dr. Mia. And I submit, my lord, my learned friend for number 2 seems to have forgotten the basis upon which Lukele was taken to be examined by Dr. Mia. And the findings of Dr. Mia, my lord, those were very relevant. My lord, just to recap, my lord, there was an application to take Lukele again for the third time. The court will remember that Lukele was treated by Dr. Ndlangamandla. On the second occasion, he was taken to a medical practitioner, which my learned friend for accused number 2 disputed. Hence, there was again a ruling by this court to take Lukele on a third occasion to Dr. Mia. And the basis upon which Lukele was taken to Dr. Mia was there's no contestation on the outcome of the report, which we all agreed to. That was the basis on which Lukele was taken to a doctor for the...
It was instead of him stripping down in court, he went to the doctor and the doctor recorded what he had.
That is so, my lord. And importantly, my lord, Dr. Mia's findings were exactly in line with the first two doctors. And Dr. Mia was even more precise as to the relevant time as to when the wounds would have been inflicted on Lukele. And therefore I submit, my lord, that was very conclusive. There couldn't have been more conclusive proof than that. Therefore, my lord, I submit that on its own, coupled now with the evidence of Peter and Paul, whom we know very well that were there during the course of the events, put matters at rest. I submit now.
Can we just deal with the principal issues here? One of the principal issues is that the drugs were never identified by experts. So now what do you say about that? The submission is a reasonable court acting carefully, properly, will not find what I found, that because you say it's this, therefore it's this.
No, there is no other court that would come to a different conclusion. Because on that, my lord, the court relied, there was evidence of doctor who says we were dealing with drugs. But importantly, my lord, we have now the admission of accused number 2, who comes to say this substance that we dealt with is XYZ. Now, what more proof does?
Against 2, maybe that's admissible.
Yes.
But what about 1 and 5?
1 and 5, my lord, were not convicted of dealing with these drugs. They were convicted on the attempts, on the basis that number 1 would not, the state failed to prove.
Was dealing in the same drugs as 2.
Exactly, but he knew that he was dealing with this substance. So I submit, my lord, there's no other court that will come to any other conclusion other than that which this court has come to. Now, my lord, criticism was made as to the fact that this court made a finding that accused number 1 was the mastermind in the transporting and exporting of these drugs. I submit, my lord, we clearly have to look at, again, the evidence of Peter and Paul.
Well, he was the boss.
That he was the boss. That everything was being reported back to him. Now, if that is the case, what other conclusion could the court have come to? I submit. The court was correct. There's no misdirection on that in that regard. And there's no any other court that is going to find otherwise.
And what about the problems raised by Mr. Spannenberg about the admissions?
My lord, we have now to deal with that issue. And there's a couple of issues emanating from that issue. The first question I submit, my lord, is the pre-sentence report. On whose behest is it procured?
Well, let's just not worry about that. The pre-sentence report came here. It contains a set of facts and opinions.
Yes.
And you were asked whether or not you agreed that the facts are correct and the opinions are correct and that they're proper opinions. And you agreed.
Yes, ma'am.
That being so, according to Mr. Spannenberg, you agreed for example, that number 6 was the person who produced the ID card?
My Lord,
Because that is one of the facts set out in that report.
Well, my Lord,
You never said, I don't agree to that.
Sorry, my Lord.
You never said, I don't agree to that. You said you did agree to that.
Yes.
So
yes,
now, as a fact, it's a fact before this court.
yes.
That's the submission.
My submission, my Lord, is we have now the evidence of Lukele, who comes here during the course of the trial.
But don't worry about the evidence of Lukele. Tell me about what you say about the admission.
No, it remains.
If you admit a fact, then it's...
My Lord, that submission remains, that evidence remains a hearsay evidence.
But you admit it.
No, my Lord.
You admit it's true and correct as a fact.
No, my submission, my Lord, is it remains a hearsay, which hearsay evidence has not been proven before this court.
But then you should have denied it.
Well, my Lord, I can't go back to whether I admitted to that, and I must
But you
say,
did admit to it.
I've read the record, that report many times
Mr.
before.
Mashiani, it's the thing I'm very careful about. I asked you, do you admit that the facts are correct? You said yes.
Yes.
One of the facts contained in the report is incorrect. At least one of the facts is incorrect. Mr. Spannenberg says, well, you've admitted it as being correct.
My Lord,
Therefore,
hence,
it's correct.
Hence, I submit. We cannot look at that fact in isolation. We have to look at that fact in conjunction with the evidence of Lukele. We know Lukele has never identified any of the accused by names or whatever. He came here to this court to say, this is the person who did XYZ. This did XYZ. Now, for somebody else to come back at a later stage to say, but Lukele said it's John, for instance. That cannot, my Lord, override in any manner the fact that Lukele came to this court and pointed the people who did the crime.
Mr. Mashiani, it's a simple question. You agreed that X was correct. Mr. Spannenberg says he relied on the fact that you agreed that X was correct, and therefore X is correct. And that's the end of it.
But my submission, my Lord, is that X is correct cannot override the evidence before this court. And the evidence before this court is Lukele came to this court and identified the people who committed the crimes.
Look, let me put it to you bluntly. Why did you admit something that's not true on your case?
Well, my Lord, I hadn't seen that up until it was brought at a later stage. That is the basis upon which it was admitted.
So you say you made a mistake?
That was a clear mistake, my Lord. There's no way I could have accepted that Lukele was kidnapped by accused number 6, whereas the evidence is to the contrary.
But you should have said so.
No, it cannot be, man. And the defense cannot take advantage of that to say then that aspect now overrides the evidence of Lukele. I submit, it cannot be.
What do you say about me being obliged to call Klimba and produce records, and you should have investigated more, and the, in inverted commas, conspiracy theory?
I submit, my Lord. There's no basis for that, my Lord. Because, my Lord, the evidence before this court and the reason why Klimba's cell phone data was not accepted, the defense could not prove relevance. We are not just here, my Lord, to while away time, grabbing every passing car. No. We know, my Lord, for evidence to be accepted before this court, it must be admissible and it must be relevant. Now, on the basis that there is no relevance before this court as to why we should now go on getting the evidence of, and it's not only of that of Klimba. The court will recall that it had to make several rulings pertaining to the cell phone data, i.e. that of General Ria Pierre that of the commander of crime intelligence, a number of other witnesses. But there was no relevance as to why we have now to source that information.
So your answer is it's irrelevant, and I correctly ruled that.
Indeed, my lord. So I submit, my lord. There's just no any other court that will find relevance in that piece of evidence to this particular trial. I submit. Now, my lord, further submissions were made that the court failed to identify the conduct and the fault element in the attempted murder charges. My lord, we have again, unfortunately, to go back to the evidence before this particular court. We know, my lord, that during the course of the commission of these crimes, accused number 1 proposed that Lukele be killed. Furthermore, we know that during the course of the commission of these crimes, accused number 5 had uttered words to the effect that we are dealing here with serious stuff, drugs, and in the taxi industry, a person is killed for something of a lesser value. Now, when we have that as evidence, my lord, the objective state of mind as at that time clearly plays a part as to what did these people intended to do. Surely, my lord, I submit.
No, they don't say that. What they say is he was injured with a view to obtaining information from him.
But now,
assuming that to be the case.
yes. But now,
now, to get the information from him, you don't want to kill him. Your answer is that means you don't want to kill him immediately. He could take long to die. Meantime, he'll talk.
yes,
That's your answer.
yes, ma'am.
So you could pour the boiling water. He might take 2 days to die.
But he will die ultimately.
Ultimately, he will die,
That is so.
and then you'll get the information in the meantime.
In the
But now
meantime,
they say, I don't want him to die.
no, that
It
is
means
not.
I don't want him to die now.
And none of them, my lord, had ever uttered the words, no, we don't want him to die.
Well, they do, because they want to interrogate him.
No. But ultimately, they want him to die. Had it not been for the intervention of
No,
Paul,
it's got to be from that act.
yes,
No, and it's not got to be from some other act.
no, man,
It's got to be from that act.
yes. Had it
So
not,
they want him to die from pouring boiling water over him.
yes, because
Okay, there are 2 problems. One, how do you know boiling water is going to kill you? That's the one thing they say. And the other thing they say is they didn't want him to die now, this minute. So your answer to the second question, I understand.
yes,
What about the first question?
but now, my lord,
That is, if you pour boiling water, a kettle of boiling water on a man's head, is he going to die?
on a very sensitive area of his body, my lord,
Well,
the
they
head.
say there should be an expert evidence to show.
No, my lord.
It doesn't mean because I pour the boiling water is going to cook your brain. That's what the submission is.
What other inference can the court draw from that action, my lord? I submit. It cannot be. And we don't need an expert to come and tell this court that boiling water can kill.
Well, that's the difference.
No, my lord.
They
No,
say yes,
no.
you
I
do.
submit.
You say no.
I submit. No, my lord.
Okay.
And therefore, my lord, I submit this court was very correct and did not misdirect itself in finding that that action could have easily led to the death of Lukele.
Mr. Machine, I just want to find out something. Mrs. van den Heever, you want to speak to your accused. Well, I think, anyway, you need to speak to accused too. And how long do you take to speak to him?
My lord, I don't think it would take longer than 15 minutes because
15 minutes.
needs
And
to
what
be.
time do the accused get taken back?
I don't know what the latest arrangement is, my lord.
Because we need just to make sure that this court stops early enough for you. I don't know what the time is now. It's 2:45.
It's 2:45.
And I'm not sure. So if we stopped at 3:45, then theoretically there should be enough time because there's court until 4.
I do recall, however, from one of the last occasions, your lordship would recall, they said they needed to leave at past, but I don't
Well,
know if that arrangement is still in place.
I can tell you something, that as far as the judge president is concerned, that arrangement can be ignored. because no one leaves here before 4, because court hours end at 4.
We're happy with that, my lord.
Right, so if I stop at 3:45, that will be enough
That
time.
would give us enough time to
Thank
take
you.
instructions.
Any of the other accused counsel want to speak to them?
We would.
The same time limit would be enough.
Yes, thank you.
Okay. Right, so Mr. Mashiani, I'm sorry to interrupt you. It means we've got about an hour for you left.
Yes, my lord, I should be done way before that, I think.
Okay.
Now, my lord, there were few submissions made in respect to, with regard to the sentence, and I would take all of the accused in addressing this aspect, my lord. Because
Before you go to sentence, what about 4 and 6? What about this issue of your admission about number 6 and the identity card? Does it impact on number 4?
sorry, my
What
lord.
is the impact of the fact that you admitted number 6 showed the ID card? What is the difference does it make?
I submit, my lord. It doesn't impact on number 4 at all, because as I indicated, number 4 was duly identified in this court by Lukele, and we also have to take into
So you
account
say it's additional matter.
it's an additional matter. And importantly, my lord, and I think I've indicated on this aspect, my lord, we need to also take into account the time factor as to when did it come into the fore. That I think, my lord, I'm still gonna go to this, most of the submissions by 3 to 6.
Okay, just wait. Okay. No, but you started talking about sentence. So I'm just trying to get
The reason why, my lord, I deal with these issues in this manner is I tend to respond as per the submissions that were made before this court. Hence, I indicate that when I deal with sentence, because my
it's
submission...
for one.
It's for one, but my submission is there hasn't been much of a difference between the submissions of all the councils.
Yeah.
Hence, I say
They say that there's submissions that I didn't take enough account, and there's a proportionality issue
that is
with number 5.
those are the only submissions. Hence, I submit I can deal with
Yeah.
all of that at one go.
Yeah.
My lord, I submit. When the court dealt with the sentencing, and we had a look at the act, the Drugs and Drug Trafficking Act, the court was precisely within the sentencing arena as provided for by the legislature.
For 1 and 2.
Yes, and on dilemma.
Yeah.
Now, the question that arises now is on the attempted murder and the kidnapping.
Right.
I submit, my lord, and I've once again gone through the court sentence, my lord. This is a well-reasoned judgment on sentence, my lord, as to the court having taken into account the gravity of the offences that the accused have been convicted of, my lord. And therefore, I submit, my lord, and that these sentences are not shockingly inappropriate, and they do not induce a sense of shock.
What about proportionality?
No. We have to look at it, my lord, from the perspective that these accused are all sentenced, for instance, on kidnapping. Therefore, if the court finds that for kidnapping you are sentenced to 15 years, then it means every accused that has been convicted of kidnapping must serve 15 years. Hence, my lord, this court was even more lenient to have ordered the sentences for other charges to run concurrently. Thus, I submit, my lord. This court has applied an element of mercy in sentencing the accused, and therefore, there's no any other court that will come to a different conclusion. And I submit that the application in this regard be dismissed. Now, my lord, I now deal with mainly the submissions by counsel for 3 and 3 to 6. And I've already dealt, my lord, with the application to have the evidence of the pre-sentencing officer admitted, my lord. Importantly, my lord, my learned friend for 3 to 6 ultimately admits or concedes that this particular application is not in terms of Section 316 of the Criminal Procedure Act. In fact, my lord, he concedes that there's no provision in the Act for this kind of application.
No, that's not quite right. What he says is this. He says, assuming there's some dispute about the ambit of your admission, then it's a question involving the need to lead the evidence. If there's no dispute about the ambit of your admission, then it's already evidence, albeit in the sentencing proceedings. That's the submission.
Well, I understood.
So 316 applies in scenario A,
Yes.
and not in B.
Yes, that is, but I submit, my lord, my understanding was that ultimately consists that the Act does not make provision for this kind of scenario.
No.
Because the evidence is already part of the record.
No, he doesn't concede anything. No.
That was my understanding. But be that as it may, my lord, I submit that, as I indicated earlier, my lord, that particular part of evidence can in no way impact on the evidence before this court. And I submit, my lord.
Well, it wouldn't, except that you admitted that it's true.
Oh, my lord, I've already indicated, my lord, that
All I'm saying is it doesn't help to keep saying it doesn't impact when it's not the case.
No, I've already made a submission, my lord, that I've read it on a number of occasions up until it was picked up by counsel for 3 to 6.
Well, what's the effect if you did make a mistake?
Then I wouldn't have accepted
What's
that
the
as a fact.
What's the authority that you want to rely on?
Sorry, my lord.
Assuming you want to say I mistakenly admitted something, then
Yes.
what authority do you rely on in relation to the mistake?
I unfortunately don't have.
What's the
any.
consequence of it?
I submit, my lord. It must be
Well,
treated
you can submit anything, but what's your authority for it?
that it be treated as a genuine mistake, and therefore it cannot impact on the evidence that was laid before this court. That is my submission.
Oh, I don't know. Mr. Spannenberg said he relied on it, failing which he might have called the witness.
No, my lord.
Not no, yes.
No, I submit, my lord. It could not have been the case.
Yeah. Okay. Well, anyway, that's
That's
very
okay.
You haven't got authority.
No, I do not have, my lord. I must indicate. Now, my lord, the further submission, my lord, was that the identification of Lukele, of accused number 4 by Lukele is incorrect. That, of course, I submit, my lord, my learned friend had indicated already that it would overlap now to SP10 and SP11. I submit, my lord. Lukele was very clear before this court when he identified accused number 4. Importantly, my lord, Lukele says, accused number 4 produced an identification, a South African Police Service identification card. And it's common cause before this court, my lord, that accused number 4 is a member of the South African Police Service. It could not have been a coincidence for Lukele that he would say, accused 4 produced an identification card.
Just wait.
If, for instance, my lord, Lukele were to come and say it was accused number 5 who had produced an identification card, that would have been something to further engage on. But as part of his identification of number 4, he says he produced an identification card. Therefore, I submit, my lord, that further corroborates the evidence of Lukele in his identification of accused number 4. And that, my lord, corroborates the evidence of Peter and Paul as regards who are the parties that were involved. So I submit, my lord, there's no misdirection on the part of the court on that.
What about Mr. Spannenberg's submission that the vehicle in which Lukele was not traveling, the other vehicle, had people in it who didn't know who was in the vehicle?
We have
in other words, they didn't know that 2 was being taken to Emily.
We have the evidence.
They didn't know that Lukele was being
I understand, madam. We have the evidence of Peter that says during the conversation, during the discussion of the trip to Emelo, accused number 3 came there. That was still at Money Point.
Well, he left before they left. He went away before the convoy left.
But as at that time, accused number 3 already knew that we are going to Emelo for XYZ.
But he didn't know that the kidnapped person would be with him.
Oh, man.
Well, and what about the other occupants of the Vito?
No.
They didn't know that chap was there. That's the point. I don't know, is it good or bad? That's what I'm asking you.
No, I submit, man. The fact that accused 3 drove with 4 and 6 to Emelo, and Peter knew that 3, 4, and 6 were driving in the Vito. It could not have been a coincidence that 4 and 6 would be driving to Emelo under those circumstances for nothing, for a joyride.
But they might be driving without Lukele, that's the point.
But they were driving a convoy.
Therefore, they would not be part of the kidnapping on that piece.
But they knew, even if we are to agree, my lord, on that, they knew that the victim was being kidnapped at Money Point. And we are not charging them separately with counts of kidnapping at Money Point, counts of kidnapping in ML. That is a single continuation of an offense. So it doesn't make any...
Isn't the point that at some stage Lukele got out of the car and spoke to some person to find a way to lead the convoy to the place?
But that was already in ML when they couldn't find...
But if they saw that, they can't say they didn't know that he was there.
No. They were already in ML as at that point. So they knew at least when on arrival to ML, at the latest, they knew that we are with Lukele now. So it wouldn't have made any difference whether en route to Emelo they knew about the presence of Lukele or not. Because now, on arrival at Emelo, they know we are with Lukele.
But they didn't know at the place because they couldn't see each other. That was the point also.
Sorry, madam.
When they got out of the car to go to the door to look for Doctor, they were too far to be identified by Lukele.
But now, as at that time, they already knew that Lukele was in their midst. Now, to take it further, madam.
Well, they say there's no express evidence. You never led evidence to say, when he got out the car, I saw him, I could act to see him. You never led such evidence.
But now, the evidence of Peter and Paul, it was very clear to say, as we couldn't find the place, we had to get some other boy to show us.
We had to get help. We had to get help to find the place.
Yes.
Which Lukele found the help.
Yes, and Lukele
and he didn't find it by screaming out of the car. He got out of the car and spoke to this person.
No, he went and got this other boy who went to show them the place.
And there was a convoy traveling.
And they traveled.
Well, that's your submission. I understand your submission.
That is, and Malad, further, after they couldn't find Doctor, there was a problem with the car key, and that is when Paul said, I came again to the Vito.
But that's Mr. Spannerberg's point. Who came there?
That was Paul.
But who came there? Did 3, 4, and 6 come there?
Sorry, madam.
The point is that was an opportunity to identify, am I right?
Yes.
So you say, well, they came to the car, therefore they were close at that time.
Yes.
Therefore, the witness could see them.
Yes.
But the witness didn't say that he saw them.
No, my lord. He said very clearly. He said
the far he couldn't see them, but you say close was okay.
yes. At the time he was at the car, Paul clearly testified. I saw them, and it was accused 3, 4, and 6. So the identification is proven beyond reasonable doubt, I submit.
Okay.
And I submit, my lord, the fact that my learned friend's submission was Peter's evidence excludes accused number 4. But as I indicated earlier, we look at the overall evidence. Paul clearly saw accused 4 there at the veto as well. So that puts the matter to rest. And my lord, the fact that 4 and 6 were not there at the money point during the discussion of the trip to Emelo becomes a non-issue. Because we know, as a matter of fact, that they did travel to Emelo. They were in the company of accused number 3. Who was there? Or who came in during the discussion about this trip?
What about the wrong day? They went on the wrong day,
No, man.
according to the cell phone record.
No, man. First, we have to recall that the cell phone records of Peter overlaps on I think it's on the 28th of June. Now, on being cross-examined on this aspect, Paul did indicate, yes, I may be wrong as to the 26th of June, but we did go there. And he
So that's
mentions
your
that
answer. They went there.
he went there, and he was in the company of Peter.
The records don't prove they didn't go there. They prove
No.
they went there.
Indeed. And we know they went there only once and for one purpose only.
So assume it's on the wrong day. That's the worst.
That doesn't change the price of the cheese now. That's a
Where's the mouse? Yeah.
Now, one of the further submission that there's no evidence that accused 3 and 6 were at Katlehong. This is totally not correct. Peter clearly saw accused number 3 at Katlehong at the garage. And we know from the garage, Peter knew that they were going to kidnap. And again, some 2-3 hours later, he finds them at Money Point in the company of the victim. Now, the court was correct in now drawing this inference that he did drive from the garage to kidnap and then to Money Point. There's no other inference that can be drawn from this facts, my lord. I submit. Again, my lord, there were submissions as regards the dog identification of accused number 5. I made
It's
my
the same
submissions.
point, yeah. We've been there.
I've-
We've dealt with that point.
Yes, my lord. Now, my lord, sorry. There's submission about the evidence of Ramwehala. The court dealt with.
Now, what do you
This-
say about all of this? That the police should have been called, you should have produced their records, I should have called them, someone should have called them.
No, which police, my lord? We know that
Well, all these extra witnesses.
sorry, my lord,
Remember, all these extra witnesses.
to come and say what? That will be the question. Because the evidence has already been presented, my lord.
Well, he seems to be, let's assume he's a figure in the proceedings because he was phoned a lot in the time. So he plays some role here.
But we don't know what role he played. He might have played a role as a co-accused.
And if the defense and the state don't want to call him, why should I call him?
There's no reason. There's no reason, man.
The
In fact, during
you would be, the defense might cry if he came and pinned them.
and then they'll cry looking
You
at the
might
court
cry
to
if
say,
they unpin him. That's the
now
point.
the court has proven the state's case.
Yes.
That is the danger. So I submit, there was no misdirection in the court dismissing the application in terms of
So
section
your answer is it's just
186, my lord.
it's irrelevant and it shouldn't do it.
As the court please. Now, lastly, my lord, I turn now to the submissions by my learned friend for number 2.
Okay. Well, they're largely the same as what we heard before.
Sorry, my lord.
It's largely the same submissions as before.
Indeed, my lord. Indeed, my lord. Hence, I submitted that these were mainly the submissions that were dealt with during the course of the trial, my lord. And I've indicated, my lord, that it's actually not correct as to how my learned friends make submissions as regards how and under what circumstances Lukele did go to Dr. Mia ultimately, my lord. I submit, my lord, that it was very clear, and furthermore, my lord, Dr. Mia's findings in that regard did exactly corroborate the other medical doctors to a greater extent. It did corroborate the evidence of Lukele to a greater extent, and therefore I submit, my lord, that there is no misdirection on the part of this court in the evaluation of that particular piece of evidence, my lord. Now, my lord, the fact that accused number 2 was not identified by Lukele does not take the matter any further, my lord, because it's common cause that accused 2 was in the company of Peter and Paul for a number of days, and tracing doctor we know. And the question will be, if accused number 2 was in the company of Peter and Paul looking for a doctor for this long, why would now Peter and Paul come to this court to say we were looking for drugs instead of saying we were looking for money? And this aspect was dealt at length during the course of my heads of argument during the trial, my lord. And I submit there's no misdirection on the part of the court in that regard. Now, my lord, the submission was made as to the absence of the photographs of the safe house, my lord. The question would be...
Well, altogether, they say the submission is there was much evidence the police could and should have produced, some of which they should have had already.
But yes, my lord. But we must remember, my lord, that the investigating officer, Captain Ramhala, did say, I did go to the safe house and it was being renovated. Now, what would have assisted in us now getting the photos? They would have...
Well, they would have known a place. They would have known where it was.
But now we have the evidence of Paul and Peter, who identified the place for us. I submit. Now, as regards the court's evaluation of the state case, my lord, I submit there is just no misdirection on the part of the court in that regard, my lord, and there's no any other court that would come to a different conclusion. Now, my lord, lastly, submission was made about Paul's evidence about the trip to Emelon not being supported by the cell phone data.
Yes.
My lord, Paul testified before this court that I didn't have my cell phone when we left for Emelon, because we had agreed that we will leave them at Money Point. So how is now cell phone evidence going to support his evidence if he did not have his cell phone with?
Well, they say at least if you produced it, they could look at it.
Sorry, my lord.
The submission is that if at least you had produced it, they could look at it.
No, my lord. The defense did have access to Paul's cell phone data. The court will recall that on a number of occasions
Yeah, but
we
there
had
may have
to.
been other phones, different things, we don't know.
Well,
What about the submission that was made about the cell phone data?
sorry, my lord.
And my question that the cell phone data must be looked at in conjunction with action.
Yes. For instance,
So you say I went and acted. You can't go from the cell phone record to you didn't act.
no.
And what about the fact of these accused are put to the council? Maybe the value of the cell phone records is little because they know that cell phones record where you are and what you're doing, and they know to use different phones because we know that from the London Road outing.
My lord, we must now recall the evidence of Paul in that regard. Paul indicated to this court that most of the time we were using the throwaway phones. And the defense took a long time in cross-examining Paul on that aspect. And Paul insisted, we used throwaway phones in the first place. Secondly, we agreed to leave our phones at the money point on our trip to Emol. Thirdly, my lord, we know that this cell phone, the accused cell phones, had been, the cell phones involved, for instance, that of Likele, we know it was dismantled so that it cannot be traced. Therefore, we're not talking of people that did not know what they were doing here. So I submit, my lord, the cell phone evidence would not have assisted in either party's case, because we know that these people knew how to come around this particular piece of
You
evidence.
say I can't draw an inference from it.
No, not at all, ma'am. Now, my
And
lord,
it's dangerous for me to call for those records.
indeed. Now, my lord, lastly, finally, there was a question of fair trial, my lord.
Fair trial.
I submit, my lord, the fact that,
Well, that goes to police conduct.
yes, which we know, my lord, that the evidence that the police sought to extract from accused number 2 was rejected before this court. So it doesn't take it any further.
Sorry, just tell me again. I didn't hear you nicely. I don't understand.
The police testified during the course of a trial within a trial. And we know the outcome of the trial within a trial was that
Was in favor of the accused.
yes, it was ruled inadmissible. Now, that should have been the close of that chapter. And how do we now bring that to say it impacted on the accused fair trial right? It cannot be.
No, it's got to do with the fact that Kemba was speaking to people all the time throughout the events. So he's some kind of shadowy character. Now they say this shadowy character may have been doing things, so he must come and talk.
But when we deal with Klimba Malot, we're dealing with
Isn't he a general? He's a general or colonel or something.
a colonel Malot, as far as I can recall. We're dealing with a person that never testified before this court.
But
So
they
it's
say I
not
should
that
have.
you're not there. We can only speculate.
But that's the issue. They say I should have called him.
Oh, Malot. I've already addressed the court on
No, you say it's relevance. Okay.
on the relevance of his.
And what about the fact I didn't let them have the data? It's relevance.
Yes.
And Pumi Piri and other witnesses,
They fall into the same category.
same category.
Yes. Because
Evidence to prove Ramahala had knowledge about Kimba.
but we know that Ramgala considered, yes, I know Timber. And what does that have to impact now? How does that now impact on the accused fair trial right? It cannot. I submit, my lord. Therefore, my lord, I submit, in conclusion, my lord, that the application as brought by the
Pro tem, you're submitting that. You've got rights to reply further.
Indeed, my lord, and I know I'm mindful of the fact that there's still some further submissions that
That are
are
coming.
still coming, my lord.
Yeah.
at this point, my lord, I've got nothing further to submit, my lord.
Thank you.
As the court, please.
So, Ms. Van Eef, you want to speak to you all want to speak to your accused.
Indeed.
You want to speak to your accused before you reply.
Ideally, my lord.
So, well, it's 3:15. It gives you 3/4 of an hour to speak to your accused. Yes. So, Mr. Mashiani, thank you. I don't know who's in control of the cells, but I assume, I know when I was a counsel, there was always a place where you could consult with your accused downstairs in the cells. I assume there's still a place where you can consult. So the accused counsel must be allowed to consult with the accused on these issues.
That would have been ages ago, man. But
No,
indeed those
but I'm not
arrangements can still
interested
be
whether
made.
it should be ages ago or tomorrow or next year. Today.
Yes, the arrangements can be made.
Today, they must be allowed to consult with their accused, so that tomorrow we can proceed and finalize this first part of this trial.
Yes, man. I don't foresee any
But well, there
hiccups
are
in that.
continuous complaints that there is difficulty of access to the accused, and I don't want to come tomorrow and be told, well, we couldn't speak to our accused, so we need time. Okay, so I'm going to stop early today on the basis that the accused are afforded access to their legal advisors, subject obviously to all the normal regulations.
As the
I mean, you can't take bread knives in there by accident. We don't want trouble here. So the security must just be maintained. Right.
My lord,
Yes.
if I may indicate also, my client has indicated that he's coughing blood, and despite his several
I
requests,
can't hear you.
my client has indicated that despite his several requests for medical attention by virtue of him coughing blood, he hasn't been afforded an opportunity to see a doctor. May I ask your lordship to please order that he is given medical attention?
No, I'm not going to order that. He must go and speak to whoever must be spoken to. Mr. Mashiani, I don't know who's in control of the prisons over here. I can't make orders against people who are not here. So, but can it be drawn to the attention of whoever that accused one says that he needs some medical treatment? As far as I understand the position, throughout he's been given whatever medical treatment he needed. But if he's not, well, he can...
Currently, that's not the case, my lord.
So currently, let him make a request.
Indeed.
Well, I think in the normal course they would endorse that on the J7.
Mr. Mashiani, I don't want to start an argument about the rights and wrongs of it. If he wants to see a doctor, let him see a doctor.
Indeed.
So can you just make sure that it happens?
I will, madam.
I'm not making orders against anyone, right? And then as far as the food is concerned, I don't know what the position is with the food, but I know that there should be food for them. So can it please be made apparent to whoever feeds them that tomorrow they must get food? Do you
I will indicate.
Can these problems be resolved? I mean, I can't resolve them from where I'm sitting, but I'm relying on you to go beyond your duty as the prosecutor
I
and
will, ma'am.
interact with the relevant personnel
Indeed, I will, ma'am.
to ensure that the accused get food tomorrow.
Indeed, I will, ma'am.
And then, okay, so I don't know what time they go home, but consult and let them go, then they can get their supper.
We're indebted to the court, my lord.
Indebted, my lord.
Okay, right. So the matter will stand until tomorrow. All accused to remain in custody, and then the accused can be taken down to the cells. Right, the court adjourns until 10 o'clock tomorrow morning.
Zonor Vakter.
Sebaran.
Ku namsha. Pabrita gitsi.
Kita
Zonor Vakter.
Honar Vate.
Ya.
Ke tse kae? Tshwantse di be itirile.
Ibuti.
E nngwe ke lara. Tshwantse di be itirile.
Sorry.
Mthako wa ka o tsamaya ka